Hello, everyone. Thank you so much for joining us today for this discussion, during which we would like to focus on real-life examples in the context of crypto regulation. As a law firm, we specialize in financial and digital asset regulation. We also provide advisory and compliance services to businesses operating in the crypto sector. Our expertise covers licensing, regulatory compliance, disputes, in general, strategic guidance under both national and EU frameworks. As most of you probably know, Bulgaria has adopted the Crypto Asset Markets Act to align with EU's MiCA framework. The law and the regulation emphasize on consumer protection through the mandatory white paper for all crypto assets, with specific requirements in relation to asset reference tokens and e-money tokens. The aim is to ensure that investors receive clear, accurate, and accessible information. I am joined today by my colleagues Maya Ivanova and Kamen Shoylev. Maya is our head of AML and compliance, and she has extensive experience in anti-money laundering regulations, sanctions, compliance in general, and crypto regulation. And our second participant is Kamen Shoylev, who is the managing partner, and his practice focuses on complex international disputes, often involving cross-border commercial, regulatory, and enforcement matters. We have decided that today's webinar will be in the form of case studies or general cases that we've experienced, that we've advised on. So I will give the word first to Maya.
Thank you, Veni, for this very warm introduction. And thank you, everyone, and good afternoon. Thank you for joining. Today, I want to guide you through a real case that shows what cross-border compliance for electronic money tokens, or EMTs, actually looks like under MiCA. And I can tell you right now, it's not as simple as one EU, one rulebook. MiCA is harmonized, yes, but once you split your business across 2 member states, you learn pretty quickly that harmonized doesn't mean identical, and it certainly doesn't mean effortless. Before we dive in, a quick note on confidentiality. We won't be disclosing which EU member state granted the authorization. Attorney-client privilege and strict confidentiality obligations prevent that. But the point of this case study isn't the specific jurisdictions. Is to show you the practical challenges and regulatory pitfalls and requirements that came up when you operate across borders. The project we are discussing involved an issuer launching a euro-denominated EMT authorized in 1 member state with all operational functions, onboarding, compliance, transaction monitoring, and ICT performed in Bulgaria. And because the issuer intended to serve Bulgarian customers directly, Bulgaria wasn't just a back office location, it was also a host market with full supervisory expectations. This created an incredibly instructive situation. 2 regulators, 1 license, 2 AML regimes, MiCA on top, PSD2 and EMD2 still fully applicable, and DORA adding a whole other layer of complexity. Let me walk you through what actually happened and what we learned. Under MiCA, 1 issuer had to meet the full EMT requirements. They needed authorization from the home competent authority, a MiCA white paper explaining the reserve model and risk control, robust governance, fully backed reserves redeemable at par, and solid risk management and incident reporting structures. Where things got interesting was everything outside MiCA. MiCA governs the offer of the EMT, but the payment and e-money services behind it still fall under PSD2 and EMD2. So our issuer needed not only MiCA authorization, but also the e-money institution passport. And they had to notify Bulgaria as a host country for those underlying payment e-money services. The Home Supervisor focused on prudential and MiCA-specific issues: reserve adequacy, liquidity, governance, redemption, and overall risk management. Bulgaria, however, looked at the business through a different lens, complementary but different. And here it's important to be precise. In Bulgaria, supervisory responsibilities depend on the activity. Payment and e-money activities generally sit with the Bulgarian National Bank. Certain crypto asset activities can involve the Financial Supervision Commission. Which authority is in play depends on the exact nature of the activity. For this project, Bulgaria's focus was operational. Onboarding performed in Sofia, AML analysts based here, resilience under DORA, customer handling, and incident processes. Both regulators were legitimate in what they cared about. They were just different. AML is not harmonized under MiCA, and it's where practical complications start to appear. The home member state applies AML in a strongly risk-based way. Aside from the EU-level €10,000 occasional transaction threshold, the home supervisor typically expects companies to rely on their own risk assessment, supported by documented methodologies. Bulgaria, by contrast, implements EU AML rules through the Prevention of Money Laundering Act, which is more perspective and threshold-driven in practice. There are mandatory triggers for certain transaction types. These thresholds can vary depending on the precise rule or implementing regulation. Excuse me. So you often see Bulgarian AML frameworks rely more on predetermined numerical triggers than other EU member states. Please excuse me. So, this meant our issuer had a home supervisor expecting flexibility and a host supervisor expecting specific mandatory checks. So we needed a way to satisfy both. The solution was a unified AML program that was risk-based at its core, but supplemented with a specific annex containing all mandatory local thresholds, documentation, obligations, and prospective rules. That way, staff followed one policy, but maintained both jurisdiction standards. We also structured escalations so they could flow to both the home member state and the Bulgarian money laundering reporting officer. In addition, the suspicion transactions report could be filed to the appropriate financial intelligence unit, depending on the case. DORA adds a deeper level of ICT, that's information and communication technology, governance, than MiCA alone. Since ICT operations were in Bulgaria, supervisors quite reasonably expected full DORA compliance locally, even though the license was in another member state. So we built an ICT monitoring center in Sofia with real-time dashboards, role-based escalation procedures, and a classification matrix capable of producing both DORA and MiCA-relevant alerts. And this became particularly important during a real incident that tested the entire system. During a scheduled maintenance, one of the custodian banks briefly paused intraday balance reporting. That pause triggered an Amber Reserve Visibility Alert. Sofia classified it as a medium ICT incident under DORA and notified the Bulgarian National Bank. But they didn't recognize that the very same loss of reserve visibility might also be a MiCA prudential incident. So, Bulgaria was informed, but the home competent authority was not. Another 90 minutes later, and the home regulator noticed gaps in the automated reserve data feed. They contacted the issuer directly, asking why no MiCA incident notification had been submitted. Suddenly, both supervisors had part of the picture, but neither had the whole thing. This wasn't catastrophic, but it was exactly the sort of operational slip that happens easily in cross-border models. While everyone was focused on fixing the reserve visibility problem, another issue came up. This one wasn't about technology, it was about the contracts of the issuer had in place. The issuer had outsourced key tasks, like collecting system logs and keeping backups to a cloud provider. On paper, the contracts seemed fine for day-to-day operations, but there were two important things missing. The right for regulators to access data directly, a requirement for the cloud provider to quickly export data in an emergency. These missing clauses didn't matter until the regulators investigating the reserve visibility issues asked for a full timestamped audit trail of transactions and system logs. When the issuer asked the cloud provider for the data, the provider said, "We can export it, but only after a manual review and a formal 30-day change request." In other words, the issuer couldn't give regulators instant access to the information they needed. The internal team panicked and sent regulators partial and inconsistent data. That made the regulators even more concerned. They needed to see the complete chain of events and prove that the issuer could track issues properly. Without the contractual rights in place, the regulators were worried about whether the data was reliable and whether the issuer could demonstrate exactly what went wrong and how they were fixing it. This is where we had to step in to guide the issuer, helping them navigate the regulatory concerns and fix the gaps in their contracts and processes. First, we established a single authoritative set of facts and told both regulators we would consolidate the response under an independent council-managed protocol. Next, we negotiated immediate temporary access with the cloud provider. On a crisis basis, we obtained time-limited forensic experts under lawyer-to-lawyer communications and secured a written certification about data integrity for the period in question. That gave the issuer the exact logs supervisors requested within a matter of hours instead of weeks. While that emergency access was in motion, we worked on a long-term fix. We redrafted the cloud contract templates to include explicit regulator access clauses, emergency data export obligations, stipulated service level agreements for forensic supports, audit rights, and continuity assurances consistent with DORA's third-party requirements. We added explicit confidentiality and privilege protections that allowed legal teams to manage sensitive disclosures to supervisors without compromising client or personal data more than necessary. We also introduced a mandatory procurement checklist and pre-approved contractual template that the issuer had to use for all critical suppliers. This meant future engagements automatically included the regulatory and DORA-compliant clauses. Finally, we coordinated a consolidated disclosure to both supervisors, a single lawyer-vetted submission with the full logs, the forensic reports, and a clear remediation plan that included the new contractual protections and a timetable for vendor replacement where necessary. The immediate effect was to restore supervisor confidence. The authorities received a complete, authenticated audit trail and a clear contractual plan to avoid a repeat. So, across both incidents, we took a layered approach. We prepared joint incident briefs to re-establish transparency. We amended outsourcing contracts to be DORA compliant and to include mandatory regulator access clauses. We rewrote internal policies so any temporary loss of reserve visibility automatically triggered dual notification without relying on individual judgment. We automated alerts so senior management and both supervisors are notified simultaneously when thresholds are crossed. We introduced contractual and procurement controls so critical suppliers cannot block timely regulator access in the future. We trained both teams together so they could deal with cross-border ICT issues, contract problems, and prudential incidents quickly and in sync. A few lessons stand out clearly when it comes to cross-border compliance. Map your activities precisely. Which ones fall under MiCA? Which fall under PSD2 and EMD2? Where do DORA and AML apply? Misclassification is the biggest source of regulatory friction. Build one AML and governance framework with local annexes, not multiple competing policies. It keeps operations consistent and regulators aligned. Set up your systems to automatically send alerts when something goes wrong. Computers are great at noticing problems at any time, even in the middle of the night. Humans are better at deciding what to do about the problem, not just noticing it. Make sure all outsourcing contracts are DORA-proof. Many firms underestimate how much DORA requires in terms of regulatory access, service level agreements, and mandatory notifications. And finally, engage both regulators early. When both authorities understand your model beforehand, supervision becomes collaborative rather than corrective. So to close, issuing an EMT in one member state while operating out of another is absolutely feasible under MiCA. But feasibility doesn't mean simplicity. You operate at the intersection of MiCA, PSD2, EMD2, DORA, the new EU AML regulation on top of the EU AML directives, and the national AML laws. When those systems meet across borders, the pressure on governance, contracts, and coordination intensifies. The key to success is transparency, consistency, and control. When regulators see that you understand both frameworks and can meet them without contradiction, supervision becomes smoother and far more constructive. And when things go wrong, as they inevitably will, the right legal, contractual, and operational fixes applied quickly make the difference between a lasting regulatory incident and a contained, fixable event. Thank you very much.
Thank you, Maya, so much for this detailed review of your most current practice. I just would like to mention for the benefit of our viewers that at the end of the session, we have a Q&A section where we welcome questions from the audience. But if you would now allow me, I personally have a couple of questions for you. So in the context of MiCA, because your case was closely focused on it, in the context of MiCA and passporting for EMTs, how does passporting work, and how does it differ from other crypto assets and in general? What are the differences that you would like to single out?
Thank you for this question. Well, under MiCA, EMTs are fiat-backed stablecoins issued only by licensed banks or e-money institutions. Once authorized in one member state, these issuers can passport their tokens across the entire EU, meaning they can offer EMTs in other countries without needing separate licenses. The key obligations include maintaining fully backed and segregated reserves, ensuring holders can redeem tokens at par value at any time, and prohibiting interest or yield on holdings. This differs from other crypto asset services such as exchanges, custody providers, or issuers of non-fiat tokens, which have a broader eligibility for authorization and typically lighter prudential requirements. While all MiCA authorized services benefit from passporting, EMT issuers face stricter regulatory standards, blending e-money safeguards with crypto assets innovation. Essentially, passporting allows pan-European reach, but EMTs stand out for their high consumer protection and stability requirements compared to other crypto assets.
Thank you for that. Also, you mentioned the importance of DORA, and I think it will be useful from the point of view of the audience. From your experience, how do DORA and MiCA interact when using specifically, in your case, but in more general, third-party service providers like cloud platforms or custodians?
Well, MiCA requires crypto firms to ensure operational continuity, security, and resilience of their services, while DORA, for example, sets detailed EU-wide rules on managing ICT risk and the outsourcing itself and critical third-party dependencies. Together, they make companies responsible for due diligence, monitoring, and contractual safeguards with providers, ensuring that critical services um, don't compromise security, data integrity, or the ability to meet obligations to clients. In practice, this means that MiCA authorized issuer using a cloud provider or custodian must not only comply with MiCA's conduct, prudential, and reserve requirements, but also follow DORA's operational resilience framework, including risk assessment, reporting, and exit strategies for third-party failures. This dual framework strengthens consumer protections and reduces systematic risks. It also ensures that crypto asset services remain secure and operational across the EU, even when relying on external providers.
Okay, and in your view, what are the common pitfalls that issuers face when they are splitting operations across two or even more than two countries? How can these be avoided, or how, if so?
Well, I think everything can be avoided. Sometimes it's on a trial and fail sort of basis, but issuers splitting operations across two EU countries or even more. It doesn't have to be two. It's just our recent case has been with two jurisdictions. It can be as many as the business model allows, as many complexity as that might arise from that multiple jurisdiction use. Excuse me. So if issuers split operation across two or more EU countries, they face regulatory, operational, and supervisory challenges. The more EU countries, the more challenges and supervisory regulatory burden there is. Under MiCA, the firm must ensure that all activities, whether issuance, custody, or consumer services, comply with the rules of the home member state. The home member state is the state that issued the authorization. Common pitfalls include unclear allocation of responsibilities between entities, inconsistent compliance processes, fragmented risk management, and insufficient reporting to the competent authorities, which can lead to breaches of prudential conduct or operational requirements. To avoid this, companies should clearly define governance structures, centralize risk management and compliance oversight, and ensure consistent policies across jurisdictions. Leveraging MiCA's passporting mechanism properly by notifying host authorities and maintaining communication with both home and host regulators helps prevent regulatory gaps. Additionally, integrating DORA-aligned ICT risk and operational resilience measures ensures that splitting operation does not compromise security, continuity, or consumer protection.
Okay, so with these layers and layers of regulation
Yes.
and compliance requirements, then can issuers use the same systems to comply with MiCA, DORA, AML, other regulations?
Yes, they can. And issuers often leverage the same system to comply with MiCA, DORA, the local AML requirements, the EU, whether it be the directives or the upcoming AML regulation that will be set up to take place in 2027. But that can happen if only those systems are designed to meet the specific obligation of each framework. So let's see. MiCA focuses on prudential safeguards, operational continuity, and consumer protection for crypto assets activities. DORA sets detailed rules on ICT risk management, resilience, and third-party oversight. And AML directives and regulation require transaction monitoring, KYC, and reporting of suspicious activities. An integrated system can cover all three areas, provided it has controls, audit trails, and reporting capabilities aligned with each regulatory requirement. However, I must say, companies must ensure that such systems are flexible and modular, so they can demonstrate compliance separately under each framework to competent authorities. This includes maintaining proper documentation, clear segregation of duties, and automatic reporting for AML obligations, while simultaneously satisfying MiCA's operational and reserve requirements and DORA's resilience and third-party management rules. Using an integrated approach reduces operational complexity, but regulators expect companies to show that all obligations are independently addressed and auditable.
Thank you, Maya. No more questions for me. I would like to let the audience address any of their questions in the comment section. But I would like to now include Kamen, who will share his most recent experience in the context of dispute resolution when it comes to crypto. Kamen, please feel free to.
Hello, everyone. I believe the reason why Nevena introduces my part of this presentation is because he is aware of this being my usual practice in connection with crypto assets. Today's light, though, is cast in a slightly different direction, it seems to me, and it is intended for on enforcement in relation to MiCA. And no matter how much I would like to have been involved in such a case, I haven't as yet acted for a party that has experienced such enforcement, or indeed for any third party in such contexts. However, I have some general comments I wish to share in relation to enforcement as a broader subject and MiCA. And if you permit me, I will be rather general and rather brief. There have been, it appears from published reports, already a substantial number of instances of enforcement, even if MiCA has only been a fact of life for a relatively short period of time, as you're aware. That of itself, I think, is remarkable, in that the intent really is to enforce MiCA, and that's an intent of ESMA, and intent generally at EU level is to enforce MiCA rapidly, and not to have a substantial, a very substantial and very extensive grace period. There is a perception among the regulators that there is a either a dearth of enforcement and enforcement need, or also that there effectively is being fair warning given of MiCA's coming and of the need for such an enforcement need, or both of these, which then it appears justifies thinking along the lines of relatively rapid and relatively severe, perhaps is a good word, enforcement. There are 19 out of 27 EU member states that have apparently reported back that they have conducted some form of enforcement. Now, it is worth, though, placing this in some perspective. And it appears that at this stage, the enforcement has not been perhaps as heavy-handed as it might have been. So I will come back shortly to a couple of cases that have been more widely reported. Neither of these cases relates to Bulgaria, but they're both EU cases at the national levels, respectively, in Italy and in Germany. And at least in the German case, and it is often said that BaFin, the German regulator, the German NCA, is particularly likely to be robust in its enforcement policy. They have nevertheless done so through a naming and warning approach by publishing warnings to the general public and issuing guidance, as opposed to through prohibition or taking more serious enforcement action. So the case that has been widely quoted in relation to BaFin concerns an algorithmic token, and that is the Athena case, with the USD token being available to the public. In relation to one of the two tokens in question, there was a finding that it was a security as a matter of European law, and of course MiCA preserves, just to be clear, it does preserve the operation of standard securities law that otherwise applies in the EU. And as such, the finding was that there has been a security warnings were issued, and those were in fact brought to the Frankfurt Administrative Court and challenged by the EVI registered issuer. So the Administrative Court in Frankfurt did not agree to issue provisional interim relief in favor of the issuer, did not find that there was enough basis against the determination that had led BaFin to publish its warnings. And therefore, effectively, those warnings were left in place. And therefore, effectively, the business that Nevena was planning to have in the German market was not going to be possible. A couple of interesting points regarding the case are that there was, of course, very limited information available to the court. It seems that its findings were mostly based on evidence provided to it by BaFin itself, by regulator. So there appears to have been, at least in that German decision, a fair amount of deference to the regulator. And it is unclear to what extent the court would have been prepared to listen to expert evidence on what was a somewhat complex by the usual standards of financial instruments, combination of instruments that were in question. there is some debate in the specialist literature, it appears, as to whether the finding that this was a security was correct. The case appeared very early on as well, and so it's worth, therefore, mentioning that one can expect perhaps relatively early responses in line with what has been forewarned by the regulators, and BAP in particular appears to have taken a very robust and so we can expect to see quite a few cases in Germany. And then it seems like such enforcement may often be through public warnings that, of course, have their weight in effect, and that those warnings may not be easily removable by issuers who find them objectionable. The second case that is worth mentioning is, in a way, more of an anticlimax, and it concerns a meme coin, the Corona coin that was made available to the Italian public. And this meme coin was advertised in various ways through various channels, social media, dedicated website and otherwise. And it was questioned by the Italian regulator why this particular project had no compliant or perhaps no white paper at all. It's unclear. It's unclear to me, at least, what the reason was for the failure to publish a white paper. But even, of course, with a white paper published, there may well be questions which can be very technical in relation to whether that white paper is compliant. And so it is worth seeking, of course, professional advice, both on the technical and on the legal side, and on the combination of the two. In terms of what themes one can foresee in enforcement, one would concern, perhaps, at least for the period up until June next year, or June 2026, when the transitional period is due to expire in relation to grandfathered casts, is whether one will still be falling, and the extent to which one will be falling within that transitional protection. It may well be that in respect of certain actions, and that was in question, for instance, in the FEMA case, at what point their reliance on a prior application would expire, and upon the withdrawal of their application, it appears that it did indeed deny to them the right to rely on their transitional rights further. But maybe there will be edge disputes in relation to how far, just for the next several months, as to how far one was within the transitional provisions. Secondly, a theme that may emerge is that although there are going to be disputes that will be relatively simple, if any analogy is drawn with the Corona meme coin, in that there was no white paper at all published in that case. Most of the disputes are likely to be not so stark. Facts in relation to them are likely to be much more nuanced. Thirdly, the fines in question that the NCAs are authorized to levy are very substantial, and some initial information suggests that they have already declared themselves willing and able to levy such fines, with an average perhaps of several million euro. And certainly they are likely to be at least in hundreds of thousands of euros. And so, so given this, again, it is worthwhile considering the effect such fines might have, and the dispute over such fine, even ultimately found to be improperly levied and set aside, are likely to have on a given project, and therefore again considering that project very carefully will be important. And then a further theme might be the connection between the pre-existing MiCA regulation of financial services space. In particular, in this case, in the Kina case, there was, of course, questions around securities and whether or not the prospectus regulation was engaged as well. But there could also be questions about the digital integrity or the quality of disclosure. And then finally, I would say that there's also an as yet unclear division of ultimate division of responsibilities. There's an element of, I think, internal discussion and contention perhaps between the NCAs and ESMA, and the degree to which this process of enforcement will be centralized and ESMAized, or it will stay in the hands of the NCAs. And maybe one can imagine getting both an appetite among some NCAs to conduct enforcement, while also there is a appetite among others, the same ones, to outsource to ESMA or centralize in the hands of ESMA either the style or the principles be applied, or the degree of enforcement. There may yet be also jurisdictions, I can imagine maybe Cyprus, Malta, and maybe others, where there's an interest in some degree of regulatory freedom and competition in the enforcement. And so it will be an interesting landscape to observe enforcement and to observe the regulatory alignment in among the different sub-regimes within MiCA. So these are my comments for today. I would expect to see further interesting reported cases around both stablecoins and also CASP generally. And it seems like historically, so historically is probably a strong word, given the relatively short period of time, most of the enforcement reported has been around stablecoins, perhaps unsurprising given that they take up a substantial volume of MiCA. But one could expect more and more CASP-related enforcement, it seems to me, as well. So watch this space. It's a very interesting one, and one can expect quite a dynamic development.
Thank you, Kamen, for sharing your insights about these two cases. Then I guess a question would be, what are the lessons learned, or what are the key takeaways in your view, based on these two examples that you've given us?
Yeah, I mean, I think it's mainly that there will be an appetite to demonstrate low tolerance, maybe not to a crazy level of of insensitivity to the market and to the relative novelty of this enforcement regime. But as mentioned at the beginning, I think that there is a perception among regulators that this has been a long time coming and very much overdue, and therefore that they will take a fairly robust approach to enforcement. So if there's one message to be taken away, is that one. Obviously, there are more nuanced things to say as well, I think, but if one message, then it's don't expect enforcement will be slow. It may be variable, of course, across NCA jurisdictions, but more and more there is a tendency to defer to a centralized driver, in this case, in the form of ESMA. So do expect that ESMA will dictate quite a tough enforcement approach.
Thank you. I can see that we have a couple of questions from the audience. One of these being, what is the easiest way to identify the intersections between MiCA and DORA for entities that must comply with both? I think, Maya, maybe this is for you.
Yeah, thank you very much, and thank you for the person who asked this. That's why we are here to try to understand the regulations more on a deeper level. I would say the easiest way to identify the intersections between MiCA and DORA is to look at where operational resilience directly supports regulatory obligations under MiCA. MiCA tells companies what must be protected: reserve integrity, issuance and redemption processes, custody of client assets, and fair, orderly, and transparent operations. DORA, on the other hand, provides the how of this protection. How are they going to be protected? The ICT risk management, incident reporting, third-party oversight, and continuity planning, needing to keep those MiCA mandated obligation functioning even under stress. When you map MiCA's critical functions against DORA's ICT controls, the overlap becomes quite visible. Maybe even more practical way to do this is to create a shared critical service inventory. List the systems, providers, and processes essential for issuing, storing, and redeeming EMTs, for example, under MiCA, and then apply DORA's ICT requirements directly to that inventory. Every place where a MiCA obligation relies on technology or a third party becomes an intersection point. This simple mapping approach highlights areas like incident reporting, outsourcing oversight, operational continuity, and governance as shared responsibility, allowing companies to build one integrated framework instead of treating MiCA and DORA as separate regimes.
Thank you, Maya. I'm looking at the at more questions from the audience. So another one is, once the new EU AML regulation becomes fully applicable, will this cross-border complexity improve?
Well, I would say that once the new AML regulation becomes, because here we have an additional layer of legislation. So far, we only had EU AML directives, which, as you all know, are not applicable as they become effective. They need to be transposed. Here now we have a regulation which becomes fully applicable across all EU member states. I think when that happens, cross-border complexity for crypto asset companies, including EMT issuers, is expected to improve, in my opinion, but not disappear entirely. The AMLR aims to harmonize rules across the EU, standardize KYC requirements, risk assessments, and reporting obligations, which should reduce the need for separate country-specific programs. For cross-border EMT operations under MiCA, this means companies can rely on a more consistent regulatory framework while still leveraging MiCA's passporting for pan-European market access. Excuse me. However, I think national competent authorities will still retain supervisory powers and some local nuances may persist. Particularly in enforcement, practices or interpretation of thresholds, maybe companies will still need a centralized, flexible AML program capable of adapting to those nuances, integrating MiCA's conduct rules and DORA's aligned operational resilience. Overall, I think that the new AMLR should simplify compliance and reduce duplication, but operational due diligence will remain key to managing cross-border risk effectively.
Thank you, Maya. I guess another viewer wants to know what constitutes a reportable incident under MiCA versus DORA, and how should firms structure internal processes to avoid duplicative reporting?
Thank you. I think that's a very interesting question. I think if we begin with MiCA, under MiCA, reportable incident for EMTs, if we take our example and our case to be, EMT includes events that reportable incidents for EMTs includes events that materially affect token stability, operational integrity, or consumer protection. Examples include the loss or mismanagement of reserves that could compromise redemption at par, critical outages in issuance or wallet infrastructure, and security breaches exposing customer funds or sensitive data. MiCA focuses on ensuring market integrity and the rights of token holders, with notifications required to the national competent authorities without undue delay, followed by detailed root cause and remediation reporting. DORA, on the other hand, targets ICT-related or operational incidents, such as cyber attacks, ransomware, cloud service outages, or failures in critical internal systems that threaten continuity, data integrity, or availability. To avoid duplicative reporting, firms should implement a centralized incident management framework that classifies events against both MiCA and DORA. This allows a single incident, for instance, as in our example, cloud provider can't give the information in the appropriate time for the national competent authority. This needs to trigger both MiCA and DORA reporting effectively, while ensuring regulators receive all requiring information without redundancy. I hope that that makes sense.
Yeah, thank you. I think we have one last question, and this would be it. I think, again, it is for you. How can firms use technology to improve compliance and operational resilience for EMTs?
Well, technology can certainly centralize MiCA, DORA, and AML obligations into one auditable platform. For example, treasury systems track reserves in real time. Monitoring software flags suspicious transactions, and ICT monitoring tools detect disruptions of third-party failures. Integrating these systems allows firms to maintain regulatory compliance, ensure operational continuity, and provide a clear audit trail to competent authority, all while supporting cross-border EMT issuance effectively.
Thank you, Maya. I don't think we have any more questions from the audience. So thank you, Kamen. Thank you, Maya. Thank you to our wonderful audience. We look forward to welcoming you to our next event. Bye.
Thank you. Bye.
Thanks, bye.